Let's move on to the next case. And Sean, you discussed with the county attorney the defendants in the Preston Lord trial as well.
Yeah, this was a hearing we had reported on earlier this week in terms of a delay on the Preston Lord murder trial. We want to get Josh's opinion on that. That Queen Creek teen was killed at a Halloween party back in 2023. And most recently, a judge did push back the trial date for the 6 suspects charged with first-degree murder. The attorneys for 6 East Valley defendants told the judge they needed more time to go over the evidence and discovery in the case. Preston's parents objected to this being done as they have sat through a lot of hearings as they wait for justice in their son's case. This is what Mitchell said this afternoon about the judge pushing that trial date back.
When we first got the submittal back in December of 2023, a lot of people were wanting very quick results on that. And I stood at this very podium and I said, this is a huge police report. It's got 600 videos and many, many other pieces of evidence. You know, while we want to get swift justice for the victim and certainly his family, it's been going on a long time for them. I understand that. It is a very complex case, and so a 6-month continuance was granted.
And the judge told each defense team earlier this week that they will have to wait until November to potentially separate their cases from one another. That is if they choose to do so. Tram.
So, Josh, in light of that, I mean, you know, is there a strategy or, you know, some kind, what's the reasoning behind having them all do this joint trial together?
Well, great question. So, you know, what the Maricopa County Attorney's Office has done is they've joined the defendants together as opposed to trying each one severally or severing the cases. The reason why they do that is because it saves time and resources. Also, because of the way that the case is charged, and they did, you know, the Maricopa County Attorney's Office has been brilliant in this case. Each defendant has joint liability or accomplice liability. So let's say that one of the defendants was the primary aggressor, even one that delivered the final blow. But one of the other defendants didn't really do too much, but he did hold Preston Lord down for a couple of seconds, and he facilitated or helped in the robbery of stealing his chain. He's equally culpable, and he can still get the same sentence for first-degree murder as the person who is the primary aggressor.
Oh, is that fair, though? I mean, that sounds like it would, you know, it would hurt the other defendant.
It does. Yeah. And it's so if you're a prosecutor, you love this strategy and you want to try to keep the defendants together because you can bring in more evidence and you can show the jury that, you know, this was it was almost like a conspiracy. And in a conspiracy or accomplice liability, you can bring in hearsay that you wouldn't ordinarily be allowed to bring in. You can bring in other types of evidence against this defendant, and the jury hears it, even though they're given a limiting instruction, which they will, which means that the jury will be told you can only consider evidence against defendant 1, but not defendant 3. But it's so difficult for a jury in reality to do that. And so the cards are going to be so stacked against these defendants if the judge does not sever the case.
Yeah, I mean, from the jury to the defendants, I mean, having it all joint together, it's kind of like a, you know, one-size-fits-all type of thing. And it sounds like that would really hurt the defense team.
It does, but there is one caveat here. So there is a Supreme Court case, U.S. v. Bruton. So what that says is that if a defendant does not take the witness stand, that the prosecutor cannot bring in his statements if he mentions any other defendant in there because it's a violation of his right to cross-examine a witness. So let's say defendant 1 said, yeah, we all did this, but he chooses not to take the witness stand. The prosecutor can't bring in that statement. So there are positive things for the defense attorneys here that limit the amount of evidence for statements that their clients may have given.
All right, interesting. Well, we'll have to wait till November to see, you know, if the defense actually files for separate trials.
Oh, and they already have, actually. Yep.
Okay,
yep.
they have.
Yep.
All right.